Morning.
Case management conferences in the matter of CF 553/2022 before His Excellency Justice Nasser al-Nasser. The claimant is represented by Al-Suwaidi and Company, and the lead counsel is Robert Slewinski. The defendant is represented by Consulis Law, and the lead counsel is Mr. Raza Mithani. Thank you very much.
Thank you. Welcome to the DFC courts. We start with the claimant.
Thank you. Firstly, do I call you Your Honour, as I'm used to in the UK, or is there some other form you prefer to be called?
No, it's okay. However you're used to.
Your Honour is perfectly polite, I think. Anyway, yes, this you've got hopefully the bundle. There were some issues with the system. It may have been at our end.
I've got the bundle, yeah.
Yeah,
Filed twice, one on 21 November and one on 23 November.
Indeed. Unfortunately, the system kept showing that it hadn't been uploaded when we thought it had been. Anyway, you have it. That's the important thing, Your Honour. You will have read, hopefully, the memorandum. This is from the claimant's viewpoint, this is a straightforward matter. There was a loan agreement between between a company, Town Square Investment, who was, we understand, a subsidiary of Omniat, and Mr. Tabari. There were issues between the parties with regards to that loan agreement, and a little later on, there was a settlement on the 12th of April 2018. And in that loan settlement contract, it was agreed that Vision Investment and Holdings Limited would become the beneficiary of the loan and the payments that had been agreed going forward. Now, in that settlement agreement, Mr. Mahdi Amjad was the guarantor. Now, I have to emphasize, Your Honour, that there is no separate guarantor agreement. The agreement for the guarantee is simply within the loan settlement agreement. The Town Square, and I'm sure Mr. Mithani will correct me if I'm wrong, is no longer an operating company. And thus the only way that Vision Investment Holdings, as the beneficiary of the loan settlement agreement, can obtain payment is by the guarantor, Mr. Amjad, making payment in accordance with the contract. That, Your Honour, is essentially the background to this matter. Mr. Amjad has not made any payments to Vision Investment, or if they had, are not full payment. Again, I'm happy for Mr. Amjad to correct me. The parties have not been able to amicably settle the matter so far, and thus this action has been launched against the guarantor for recovery of the outstanding loan.
Thank you.
The parties have provided case management information, Your Honour, which is before you, and we've agreed a draft order for case management, which I also hope is before you, Your Honour. So the only part of the case management order that does not deal with a matter that I raised in my case management information sheet, which was the possibility of mediation. But myself and Mr. Mithani can discuss that at a later date. It doesn't need to be by way of a court order.
Mm-hmm. And the rest is all agreed, yeah?
Your Honour, yes, indeed.
Just a minute, please. Anything from the defendant?
Sorry, Mr. Mithani, you're on mute.
I can't believe that still happens after about 2 years of using Teams and Zoom, but it seems to occasionally. Your Honour, just a couple of points on behalf of the defendant by way of clarification. The first is in relation to Town Square not being an entity that's currently operating. That's actually incorrect. Town Square continues to operate, so that perhaps helps my learned friend. In terms of other points, as Mr. Slewinski rightly pointed out, there's a draft order which has been agreed by the parties. There are a couple of matters which are not expressly addressed in that draft, but are probably worth me just flagging for the information of the court. And these are matters which I've discussed with my learned friend beforehand. The first is in relation to mediation. The defendant is very happy to consider mediation, and that is something that my learned friend and I have said we can discuss further afterwards. So no order from the court is required in respect of mediation at this point in time. The second point that I wanted to flag was just a small one. It's a mistake on the case management information sheet. Because on the case management information sheet, it says that the advocate for trial will be Mr. Mohammed Zaman QC, who's actually one of our lawyers, consultant with our firm, but I will be the advocate for trial, not Mr. Zaman. There was a problem with the drop-down menu on the court system. So it was only showing Mr. Mohammed Zaman, not Mr. Mohammed Raza Nafani, but hopefully that's not too much of an issue. And then the third point by way of clarification is that we are likely to make an application for strikeout and or summary judgment. Now, that's not specifically provided for in the timetable, because whether that application is likely to be made is something on which a final decision will probably be after close of pleadings, as would usually be the case. But the reason I simply wanted to flag it for the court is because I assume that in the event a strikeout application is made, then the rest of the timetable would be stayed, because there would be time that would be required by the judge dealing with that application to render the judgment. And of course, it would it wouldn't give the parties a cost saving if the rest of the timetable continued to tick on whilst the judge was considering his judgment on that application and issuing his judgment. I assume that there's no issue from the claimant's part in relation to that.
No, that's a matter for the defendant, of course.
Well, in this case, actually, there is no application yet filed, yeah?
No.
And it's not even mentioned in this case management order. So what will happen is we'll move on with the case management order, and we'll issue the case management order as agreed between the parties. If an application for strikeout or immediate judgment is filed, then eventually the timetable will stop until this application is determined.
I'm grateful.
Yeah. So far, I think when there is no application filed, I think it's better that we issue and move on with the case management order.
Indeed, and that was the reason why my learned friend and I decided that there shouldn't be specific provision in the timetable yet for the application. Let's wait to see if the application is made.
Then if an application was filed and determined, then the case management order can be amended, yeah?
If yes.
Your Honour, yes, that makes perfect sense.
Anything else? So this case management order is fine with the parties, yeah? The courts will issue it and will seal and issue it. If this is the case management order the parties agreed on.
Your Honour, thank you, yes.
Thank you.
Anything else from the parties in terms of case management?
From the claimants, no, Your Honour.
To about the defendant?
Nothing from the defendant.
Thank you, both parties. I think the matter is resolved for today. Yeah? The
you
registry
very
will issue the order in due course. Thank you.
Thank you, Your Honour.
Thank you.